Hello and welcome to the United States Patent and Trademark Office webinar series for experienced practitioners. Today's topic is avoiding attorney scams and bad behavior. My name is Marisa Terrell and I'm an attorney in the Trademark's Customer Outreach Office. And as always, I'm pleased to serve as your host. As you may know, trademark scams are on the rise, and bad actors are using increasingly devious and creative means to fool U.S. trademark attorneys and their clients. In today's panel discussion, our experts from the Register Protection Office will discuss trademark scams and how those scams are affecting trademark attorneys. And then we'll hear from an expert from the Office of Enrollment and Discipline who will discuss common pitfalls to avoid as a trademark attorney. Throughout the presentations, we will share best practices and practical tips for protecting yourself and your clients. Now, before I introduce our experts, I'd like to share just a few announcements with you. This session is being recorded for your convenience, and you'll have access to the recording in about 3 weeks or so by visiting our website, uspto.gov. We're providing live captions to help everyone better understand the audio, and you can access the captioning in two ways. You can check the chat box for a live link, or you can also click on the closed captioning icon. You'll see a text bubble with the CC lettering on your bottom left. If you don't see that, just tap on those three dots and you should see it there. Let me tell you where you can find that chat window. Well, as soon as I finish the announcements, you'll be able to access actually, you can access that feature right now. You can find your chat window at the bottom right on the screen. If you don't see it, simply look to the bottom right and click on those three dots right there, and you should see that chat window, and you'll see a Q&A window as well. You can use your Q&A window to submit your questions to us today. And we've got a number of terrific experts standing by to respond to your questions in real time. How do you submit your question? Well, simply type your question into the Q&A window and hit enter. Notice that the Q&A feature right now is turned off. Our producer Jay is going to turn that feature on when I finish these announcements. At the conclusion of the presentation, time permitting, we're going to open up the discussion for a live Q&A segment. You can notice also that we've got some presentation slides, some really great slides today. You should have received these slides via an email that came from Eventbrite. If you haven't received them, please check the chat window for a link to that slide deck. The slides will also be emailed to you today at 3:30 p.m. Eastern Time via Eventbrite. And finally, we've applied for CLE credit in Virginia for this presentation. And as soon as we receive approval, we will email you the CLE documentation. That CLE documentation will be sent out to all attendees. The documentation will include instructions on how you can apply for your CLE credit outside of Virginia. And if you have any additional questions about the CLE process, just email us at tmwebinar@uspto.gov. That's tmwebinar@uspto.gov. At this point, I'm going to go ahead and introduce our expert presenters from the Register Protection Office and Trademark Legal Policy. Our first expert presenter is attorney Sarah France. Attorney France has been with the USPTO since 2015 and is currently a staff attorney in the Register Protection Office. Our second expert is David Meyer. Attorney Meyer is a staff attorney in the Trademark Legal Policy Office, where he has been a specialist on improper filing behavior for the past 6 years. David is a former examining attorney and previously worked at a large firm doing IP litigation and trademark work, and helped to run a nonprofit that provides legal assistance to artists. Before his legal career, David worked for several years in the film industry. At this point, we will have their presentation. We'll start it now.
Thanks, Marisa. Good afternoon. Today we will be presenting on some of the scams we are seeing in the trademarks world and sharing some tips on how you can hopefully keep yourself and your clients from becoming victims. My name is Sarah Franz, and I'm a staff attorney in the Register Protection Office. I'm joined by my colleague, David Mayer, who's a staff attorney in the Legal Policy Office. And now I will kick us off. Today, we will provide you with a brief introduction, followed by some information about several scams we have seen recently in trademarks, solicitation scams, which target attorneys, and a variety of impersonation scams in which scammers attempt to impersonate USPTO employees or others. Finally, we'll provide you with some helpful tips on how you can protect yourself and your clients against these scams. So why a presentation on scams? Many government agencies have seen a steady increase in the number and variety of scams. Here at the USPTO, the scams we are seeing relate to all phases of trademark registration. Some target individuals who have not yet filed a trademark application, but perhaps are working on designing a logo for their business. Some target individuals who have filed a trademark application with the USPTO, and others target those who already have a registered trademark. And there are new scams every day, many of which are more sophisticated than the last. The goal here today is to give you some tools to help you protect yourself and your clients against some of the scams that we are seeing target USPTO trademark customers. There are three main types of solicitation scams we see targeting attorneys who practice in trademarks at the USPTO. The first are sponsorship scams, where an attorney is asked to use their attorney role USPTO.gov account to sponsor one or more support staff accounts. And unfortunately, these accounts are not intended to be used by the attorney's actual support staff, but by the scammer. The second category involves filing mill scams, and the third is fake correspondence scams. I kind of lump these two together because they both involve a scammer using an attorney's name and bar information or other information to lend credibility to scams and to steal money or other personal information from victims. And please note that today we are talking about scams, not those situations where attorneys have consented to the use of their information with clients or by third-party filing firms. Okay, so next we'd like to address a specific scam we see targeting attorneys related to sponsored accounts. But first, a quick little overview about ID verification. So what is ID verification? As you all know, since August 2022, attorneys and mark owners must use an ID verified USPTO.gov account. ID verification can be achieved in a couple of different ways: electronically using ID.me, or on paper by submitting a notarized form to the USPTO. And as you also probably well know, ID verification for sponsored support staff accounts has been required since January 20th of 2024. And here's a brief outline of who you may sponsor under the Trademark Verified Account Agreement, available at the USPTO website, and I strongly encourage you to read it in its entirety. You may only sponsor accounts used by your support staff, and that includes those directly employed or retained by you, your company, or law firm, who are under your direct supervision. You must also immediately remove sponsorship from any accounts for those who are no longer under your supervision for whatever reason. Not only is this outlined in the account agreement, but it's also in your best interest, and we're about to discuss why that may be. Please remember that under the account agreement, you are personally, professionally, and ethically responsible for the conduct of your support staff in their use of USPTO.gov accounts, and that failure to do so may result in some very not fun things. That might include a sponsored account shutdown order, which limits your use of support staff accounts. It also might result in a referral to our friends over in OED, and they will discuss a bit more about that in their portion of the presentation. So suffices to say, please make sure your support staff is abiding by the terms of the account agreement. So now, how do these sponsorship scams work? First of all, an attorney is hired by a firm or trademark filing business. I have that in quotes because the attorney here isn't being hired for their legal expertise, but rather for their ability to sponsor accounts. The sponsored accounts are then used to file whatever it is the scammer wants. This can include documents that are used in turn to scam third parties. Oftentimes, the attorney is none the wiser, and even if the attorney is the wiser, these sponsored accounts can be used until the attorney removes sponsorship from an account. So what is the best way to avoid these scams? Well, by following the rules as set forth in the account agreement. If in doubt, reread the account agreement and then read it again, and then tell all your friends to read it too. But in all seriousness, if you are asked to sponsor paralegals or other support staff, make sure they are known to you, that you are able to supervise their work, and that they understand their obligations under the agreement. And if in doubt, don't sponsor or remove the sponsorship. All right, now let's get into the filing mill scams. Now, please note this is not a situation where an attorney knowingly contracts with a trademark filing company and offers services, preferably within the rules that our friends over in OED deal with. This is a situation where an attorney is brought in solely for the use of their name and credentials and not their professional expertise. The twist here, attorneys aren't always in on the plan. Now, how do you know if you're about to be scammed by a filing mill? Well, generally what you will see is a solicitation on a gig work site. And in case you're not familiar with gig work sites, they are sites where freelance work is often advertised. So you will see either a solicitation or be solicited on one of these sites. Or sometimes you will receive direct email correspondence. The organization will often offer to pay you per submission, and often you need not have any experience in trademarks to be hired. Now, are all of these solicitation scams? No. But if all of these things are true, gig work, paid per submission, no experience necessary, should you ask questions about the arrangement? Absolutely. Why? Because situations can arise where your name and bar information are used without your consent, either during the arrangement or long after it has ended. Sometimes we see this happen, unfortunately, even when an attorney has not become involved with a scammer, but a scammer finds their name and bar information online. However, we urge caution and asking lots of questions before you're involving yourself in a situation that may turn out to be a scam. Here's an example of a solicitation that you may find suspicious and that many of you reported to us that you had received. As you can see, the sender is interested in a US license and mailing address. They even go so far as to say they pay a fee for use of your license and mailing address in registered US trademarks. This should cause you to ask some questions, such as how exactly will my name and bar information be used, and who exactly am I working with? So in short, how do you avoid these scams? First, know who you are working with. What is the name of the filing firm you are doing business with? Search it online. Do other attorneys work there? Can you contact them and ask what it is like to work there? Treat this like you would any other job and do your due diligence. And also, we have a trademark decisions and proceedings search tool where you can find a list of filing mills that have been sanctioned. Please feel free to use it to look to see if a filing firm you are about to work with is in there. Second, monitor how your name and bar information is being used using TM search. It's easy. Just search for your own name every so often and make sure that whatever is in there definitely belongs to you. It's also a great way to see what your sponsored support staff has been up to. Okay, the last scam I will touch on are fake correspondence scams. This is essentially where an attorney's name and bar information are used to correspond with scam victims in an effort to make a scam look more credible. Unfortunately, we've seen this happen with our own examining attorneys too. What's scary about this is that it may happen without your knowledge because it's possible nothing will actually be filed using your name. Here's an example of a scam where this occurred. There was no attorney by this name that worked for an organization called Zuriel Law, nor did they look anything like the person in the picture. But the scammers used her name and identity to correspond with and build credibility with victims, and unfortunately, steal money. Now, like I said, these can be very hard to detect because it's possible nothing will have been filed by the scammers. Sometimes attorneys learn their name is being used because a so-called client reaches out to them about their trademark application. And sometimes they don't even practice in trademarks. Other times, there are filings submitted in their name by searching USPTO filings. Either way, if you get wind of this, please let us know, and please contact appropriate law enforcement. This may be the FBI, FTC, or others. My colleague David will touch more on this. Also, consider notifying your state bar in case they receive any complaints about your so-called trademark practice. Finally, periodically check your name on TM search. If something has been filed using your name and bar information and you don't recognize it, please reach out. Now, thank you for your time, and I will turn it over to my colleague, David Mayer, to discuss impersonation scams.
Thank you all, and we're going to talk a little bit about these impersonation scams. The Federal Trade Commission is reporting that scams involving impersonation of government agency employees are on the rise. Scammers often call or email and provide official looking or sounding employee ID numbers. They may have pulled in public information about you that they can use to manipulate you into believing that they have some official record in front of themselves. Most importantly, and this is going to be a theme throughout the remainder of these slides, they're going to try to use false urgency to get you or your client to provide money or provide private data that can be leveraged for other uses. So, of course, impersonation of a government employee is illegal. The FTC even has some new rulemaking. They issued a final rule in February that specifically makes it a unfair or deceptive act to materially or falsely pose as a government entity or business, or materially misrepresent or endorse, or including endorsement or sponsorship by a government entity or business. So as the quote appears here, you'll see that even the FTC is warning that they're going to try to get you to do something immediately. Most government agencies are not calling, emailing, texting, or messaging people to ask for money or personal information. That's what a scammer does. Now, this primarily is affecting the Social Security Administration, the IRS, and Medicare, but the FTC even recognizes other agencies are being used in this way, including the USPTO. So how are they using the USPTO? Well, here they're impersonating or spoofing USPTO employees through the phone. USPTO is aware of several of these attempts to impersonate USPTO personnel involving trademarks in particular. So bad actors will call to commit these scams, and we're also aware of certain scams involved using these bad actors that include false written correspondence. So we encourage you to report and have your clients report all instances of government impersonation to the FTC. Now, there's a link up on the screen there, reportfraud.ftc.gov with a hashtag and a question mark there. When we distribute the slides, I urge you to use this link. You can use just reportfraud.ftc.gov, but the FTC has actually asked us to share this particular link for reporting scams involving impersonation of USPTO employees, specifically for trademark matters. So what is caller ID spoofing? Well, spoofing is when a caller deliberately falsifies the information that is transmitted to your caller ID display to disguise their identity. They're often going to use a phone number from a company or government agency that you already trust, that you already have a relationship with. If you answer, they're going to use scripts, very elaborately developed scripts, to try to steal your money or valuable personal information, which can later be used in fraudulent activity. Well, who's being contacted? Who's being called by these? Most frequently, we're hearing from current trademark applicants who just filed an application. We've also received some reports from applicants with recently abandoned application who get these types of spoof calls also. Often with claims that somebody is going to revive or fix something with their particular application. We believe that scammers are taking data from our public records and calling recent applicants to solicit services, and frequently they're impersonating USPTO employees. Now, what you may be thinking here is that generally, of course, if an applicant is represented by counsel, then the USPTO is only going to communicate with the attorney of record on that application. But in this case, it doesn't matter if the applicant is represented by counsel, because the scammer will call or email the applicant directly if they have contact information. And we've even heard of a bunch of instances where the scammers have called the attorney and tried these scams on the attorney directly. So we do want to let you know, of course, USPTO examining attorneys do call applicants to address outstanding requirements that can be addressed by an examiner's amendment, but they're never going to request credit card information over the phone, because USPTO payments are processed by pay.gov through the USPTO.gov website. When you're filing with the Trademark Electronic Application System, or TEAS, they're processed that way. So a request for payment to the USPTO by any other means is a red flag. End the communication immediately and tell your clients to end that communication immediately. It's less common, but also we want you to be aware that even individuals and businesses who have never filed with the USPTO have been targeted for trademark-related scams. We think that scammers may be looking at recent state filings related to incorporation, business formation, changing business entity names, or maybe fictitious name filings. Again, one of the big themes here is the scammers are going to try to create false urgency. Most of the callers, the calls that have been reported to us include a request for prompt payment, usually a short time frame. You have to do it now, or 24 hours, or 48 hours. When a scammer calls to impersonate USPTO employees, usually it includes some sort of threat that if you don't pay immediately, there'll be some delay in the trademark application, or that a third party is filing for the exact same trademark and that you'll somehow lose priority or your client will lose priority. But again, big takeaway, of course, USPTO employees do not request payment over the phone. It's often difficult to distinguish a spoof call from an authentic call using caller ID alone, because that's exactly how the scam is operating. They're spoofing real USPTO phone numbers, indicating the call is usually coming from Alexandria, Virginia, but sometimes also we've heard of regional offices like the Denver office being spoofed. Sometimes when the caller will actually use the name of a real USPTO examining attorney and just impersonate them. That's why it's very important to be cautious of potential scammers when receiving unsolicited phone calls related to a trademark. Scammers have even told applicants or attorneys to go ahead and do an internet search of that phone number just to prove that the call must be authentic. And of course, they're doing this to create a false sense of trust. So be on the lookout for demands for unnecessary or nonsensical fees. If you're not already, become familiar with the USPTO's fees by going to the USPTO trademark fee information webpage. If you go to our main webpage and click on trademarks, the fee information, there's a link right there. Sometimes the amount of the requested fees itself, that could raise suspicions. We've heard of requests for thousands of dollars of fees for procedures that just don't exist, like federal taxes on your trademark application or attestation from all 50 states. You can also identify USPTO employees on our website and request to call them back. The USPTO employee phone numbers are all listed in the employee directory right on the USPTO website. So when in doubt, you could say, okay, I understand you're calling and I understand who you say you are. I'm going to call you back, and look up the number and then call that person back on the phone. Now, I'm going to talk a little bit about one particular scam, the ABAC scam. ABAC was operating dozens of logo design and alleged low-cost trademark registration websites, usually offering $49 or $99 trademark registrations. These websites would try to make applicants, and the emails associated with these websites, would try to make applicants believe that they were working with a real attorney. Generally, we're advising applicants to be aware of companies that say they aren't law firms, but that they are attorneys or that they can do trademark work, and to be cautious of people who are offering these services on personal websites like the gig work websites that Sarah was talking about before. We're going to discuss and show some specific examples, but we're particularly concerned here with conflicting mark notices, impersonation of attorneys, fake USPTO correspondence, and fake cease and desist letters that claim to be from actual law firms. Again, overall theme here, false urgency. So the scammers are going to try to create that false urgency to respond to their requests and set false deadlines to try to get people to pay them before they have a chance to do due diligence or look into the matter. Now, in the case of ABAC, thousands of trademark applications were terminated as part of the scam because the USPTO just simply couldn't rely on any of the information that was actually in the applications. Despite those sanctions, ABAC and other entities related to it are continuing to engage in this type of behavior. There are hundreds of additional logo design and alleged low-cost registration websites that are continuing to operate, and it keeps getting more complex. And I'm going to show you how the flat fees, those $49, $99 fees, quickly escalate. So the way this actually works is that a victim will receive a convincing email that claims that somebody else is going to register their logo, their mark, or their business name with the USPTO, and if they don't act immediately, that person, that victim, is going to lose rights to their business name, their logo, or their trademark. The email could be from a logo or web design website that the victim already used. A lot of these scams come from the fact that the scammer is running an actual design business of some sort. Whether they actually use the logo or the web design that was created is a separate question, but the victim will have provided information about their business to the website. It could be from an alleged trademark specialist or an alleged attorney from a particular domain name. Now, these domains usually sound something like trademarksomething.com or brandsomething.com, but they could, and we have seen examples, include USPTO right in the domain name. USPTOtrademarks.com was one of them. It could be also a combination of all of these, all of the above. We've seen examples where a fake piece of correspondence is allegedly sent to the logo design website, and then the logo design website forwards on that alleged message from the USPTO to a victim, claiming that somebody else is going to register their mark if they don't act immediately. Now, once the victim pays that bad actor, the bad actor is going to collect all the basic information about the victim and purport to do a search completion report. So the generated report informs the victim that the USPTO has somehow predetermined that the appropriate classes that need to be paid for in this particular application. And very often, of course, the scammer will claim that the USPTO has determined that their business requires 3, 4, 5, 8 classes, when the victim may be actually, insofar as they actually have a trademark, they may actually be only using or using the mark in connection with goods or services in one class. So the victim then pays that inflated filing fee, and the scammer may, and in some cases sadly may not, file an application on the victim's behalf. If an application is actually filed, it's almost universally a single class application rather than a multi-class one. It's usually a T's plus submission, which is a $250 fee per class rather than T's standard. And the bad actor will have charged the victim $350 for T's standard, multiplied out towards these extra for these extra classes that don't actually are not actually included in the application. The identification of goods and services is often wildly different from what the goods or services that were identified in the search report or in other correspondence with that victim. But that's not the end of the scam. Once an application is actually filed, the scammers will begin to periodically demand more fees. They're very good at this. They make the demands slowly over time. It's not just the next day. It could be 2 weeks, 3 weeks, 4 weeks later. And they try to maximize the response and convince victims that it's just this one more fee. And if they don't pay that one more fee immediately, then all those previous fees they paid will have been for nothing. So it's very convincing the way that they operate. Now, how do they actually go about this? They do this by creating fake letters and office actions, very often on fake USPTO letterhead. The scammers call the victims and sometimes even conference in somebody claiming to be a fake examining attorney, or they don't claim to be fake, they claim to be a real one, but a fake person, a fake employee of the PTO who will then just confirm what the scammer is telling them. The fees that we normally see are sometimes completely made up. For example, these 50 state attestations that I told you about, and it may sound like a reasonable number. They may say, oh, it's $50 per attestation, but times all 50 states. Other examples include claiming that they have to file a notice of opposition to ward off potential opposition, or filing a Section 8 and 9 while it's in the middle of prosecution. And as most of you probably know, these types of fees, notice of opposition would be to file if you're opposing somebody else's mark. A Section 8 and 9, that's a submission that is due 9 to 10 years after registration and not part of the prosecution process. So of course, one thing to notify clients about, and one thing to be aware of in general, is that real office actions are made part of the official record in the Trademark Status and Document Retrieval System, or TSDR. At least within a couple of days of issuance. We know that there's sometimes a delay between getting notice and the document popping up, but it's always within a couple of days. And in most of these cases, the victim's applications haven't even been examined yet, let alone any sort of office action being issued. So this is the type of letter we're talking about. And I know it's very small. Don't worry, I'm going to blow up sections of this so we can talk about it. But this is the type of letter that people receive. Now, they're not always identical to this. We've seen lots of variations on slightly different versions of letterhead. The watermark might be different. There may be the gold seal here or on the left or the right, but very often they're using the USPTO seal all over the document. So things to look out for. One, look for typographical errors and tell your clients these are the things they need to be looking out for. In this case, the letterhead indicates that it comes from the Department of Commerce, not Department of Commerce. Other examples, the wrong office. They identify very often, they'll say the patent office, or in this case, the patents office has successfully received required office to action. Again, these are grammatical errors. They're looking for grammatical errors throughout. Typographical errors in correspondence does happen sometimes, but mistakes in letterhead or frequent nonsensical statements are a huge red flag. Look for nonsense fees. There's no such thing as a registration ID issuance fee. There's no such thing as federal taxes on a trademark submission. And finally, again, as I sort of mentioned here, bad actors frequently will misuse government seals. The USPTO doesn't issue office actions with the seal anywhere on them, let alone plaster it in multiple places across the document. When in doubt, contact the USPTO using direct email or the contact phone numbers published on our website. You can contact the Trademark Assistance Center. You can have your clients contact the Trademark Assistance Center, or you can contact the Trademark Assistance Center. They love talking to attorneys too. And of course, go ahead and check TSDR. Enter the serial number of an application, and you can look under the Documents tab, and you'll see if an actual office action issued. These are also the kinds of things we see. We see these fake invoices, sometimes with the USPTO logo right at the top. This is a real example that a victim sent us. First thing, of course, the USPTO doesn't issue invoices. We don't send out bills with our logos at the top. Fees that accompany real submissions, as I mentioned before, are paid via credit or debit card via pay.gov, or sometimes with deposit accounts. Some of you probably have deposit accounts. And they're always handled while the submission that requires a fee is being made in TEAS, in the Trademark Electronic Application System. So look out for these nonsense fees again. In this case, they were asking for an EIN business number registration. And of course, the USPTO does not register employee identification numbers, and we don't even handle employee identification numbers. And again, this attestation is brought up. So at the bottom here, I wanted to note that it says final payment, nothing else required for you to pay in future. This is an example of that just one more fee mentality that the bad actors like to employ. It's also a good example of this idea of they will sometimes charge extra to get the lifetime registration, and this seems to be an example of that. These unexpected fees are how those $99 flat fee registrations end up, escalating very quickly into a much more expensive scam. Now, it's not pictured here, but another example that I want people to be aware of is that scammers will also try sometimes to use the US class designations, since most international classes are actually cross-referenced with 3 or more US classes. So that's something to be aware of if you have a client come to you who may have been a victim of one of these scams. That may be what's going on. They may be trying to fool them into saying, look, there are the US US classes listed on our website. The USPTO charges fees based on international classes. The US classes are essentially a bit of a throwback. So we don't want people to be confused about that. So what happens when a victim keeps pushing the scammer to say, okay, I paid all your fees, where's my trademark application, where's my trademark registration? So bad actors will sometimes, they've been known to actually try to prove their work by showing these fake certificates. So many of you probably realize trademark certificates don't look like this. The real certificate will identify the mark, the owner, the registrant, the goods and services with which the registrant uses the mark. So in this case, we have the incorrect seal. That's not the USPTO seal at the top. There's signs of digital tampering. Look for these things. It says your trademark here, and if you notice very, very finely behind it, there's a little line around it because this is something that they were changing regularly. There's no reference to the owner of the mark. There's no reference to the goods and services. There's no indication of the dates of use of this mark. And in this case too, there's also a signature from Q. Todd Dickinson, and it says Acting Commissioner of Patents and Trademarks. Well, that's not a title that the USPTO uses anymore. These types of things are signed by the director or somebody performing the functions and duties of the director. And in this particular case, the signature here is that of a person who ran the agency in the late 90s and early 2000s and actually passed away several years ago. This, of course, is what an actual current USPTO trademark registration certificate looks like. You'll notice the top left has a digital signature on it. The seal does not look like an image of a photographic version of a seal anymore. It's now this digital version. But notice the classes are listed out, the goods and services, the dates of use, other information about the mark, including the original serial number of the application and the filing date. All of that is present. There is one other version, of course, of certificates. There are the new presentation copies, which I should note do not look like the version on the left, but do not actually have the goods and services listed. So, but either way, this is just not what they look like, these certificates on the left. With that, I'm going to change gears a little bit. I want to talk about a little bit about all the things we've talked about so far, but more specifically, how you can use this information to protect yourself as an attorney and to protect your clients, and ways to educate your clients specifically. So what can you do to help protect yourself from these scams first? So you want to make sure that the email address that you're using to establish your USPTO.gov account and to complete ID verification is secure and under your control. If you have a USPTO.gov account and you completed ID verification using an email address that is not under your control, or you become aware of a third party using your username and password, please contact the USPTO and ID me as soon as possible. You need to remember to check those rules and obligations, understand what your obligations are when you sponsor an account. And of course, if you do become aware of these unauthorized changes, please change your password as soon as possible. So how do you protect your clients for USPTO.gov purposes? Well, one, tell clients to be very skeptical of any communication regarding ID verification unless they reached out to the USPTO or ID me and asked specifically for help with the process. Unsolicited communications offering to help with ID verification are a huge red flag. Now, very important to note that verification and USPTO.gov accounts in general are unnecessary for most clients. A client using the e-signature option, where you email the signature box to the applicant, do not require login to actually use. But there are clients who want to be able to file certain documents on their own. They may want to take over once you have helped with registration, maybe for post-registration purposes, or the ability to be able to file change of address forms and to revoke you and appoint somebody else potentially. If they need to do it, they have to verify their own identity and maintain their own accounts. Final reminder, you have to create your own USPTO.gov account, and please do not share your USPTO.gov account, the username or password, with any other person. And of course, the USPTO does not create the account for a person. It has to be requested by the person who wants that account. So protecting yourself again, unauthorized practice of law. As Sarah demonstrated, you need to be aware and be careful about those cooperation solicitations that we discussed. Even if you didn't respond to a cooperation solicitation, if you believe your name, your bar number, or other identifying information is being used without your consent in a USPTO submission, contact the USPTO as soon as possible. Just like applicants, attorneys have been victims of scams. So be wary of potential phishing attempts and other social engineering scams that try to get you to provide any information about yourself that could be used by a scammer. And of course, if you have questions about register protection issues, email tmscams@uspto.gov. And if you have questions about your ethical obligations, you can always contact the Office of Enrollment and Discipline directly at oed@uspto.gov. With regards to unauthorized practice of law, how can you protect a client? What can you advise your client? Well, let your clients know that the USPTO is going to talk to you and not them. If a person is represented before the office in a trademark matter, the USPTO is going to communicate with the attorney and not the applicant directly. Also instruct clients to check with you before giving out any information over the phone from somebody claiming to be calling from the USPTO. Now, again, an assigned examining attorney may call or email to seek a minor amendment to an application, but these communications are going to be with the applicant's counsel if the applicant is represented. And it's going to be months before an examining attorney is assigned. Current pendency is around 8 months, I believe, right now. We have a website that designates the current wait times. So if an applicant hears from somebody claiming to be from the USPTO days or weeks after an application is filed, that's a red flag also. You want to explain to them that once a mark is registered, they may receive courtesy email reminders from the USPTO about registration maintenance, but they're also going to receive emails or correspondence from scammers, sometimes well in advance of USPTO deadlines. It's almost a given that a scammer is going to contact them using names very similar to USPTO or the United States Patent and Trademark Office in order to fool them. They're going to ask for payments, typically for amounts much higher than the USPTO's actual fees. So they can avoid being scammed by contacting counsel if they have questions or checking actual filing deadlines using TSDR and the amount of USPTO filing fees by reviewing the trademark fees on uspto.gov. And be skeptical of all unsolicited communication. The USPTO will not take payment information via text, phone, or email. And again, false urgency is the big part of the scam. There are deadlines, but the USPTO is not going to send out surprise office actions with immediate action required. If your client or even you have questions about a communication, you can check with us. Contact the Trademark Assistance Center to ask about a document, a phone call, or an email. Attorneys, just like pro se applicants, can make use of that resource. Another point, especially for less sophisticated or new clients, is that they may be directed toward a scam by a search engine. So if you have a client tell you that they found out about a scam via a search engine, you can actually help them report that to the search engine company. Complaints from the general public to these companies help remove those ads from circulation and stop the promotion of the scam. So I sort of hinted at this, but post-registration solicitation scams are still a big problem. They will usually target registrants up to 2 years before the maintenance submissions are actually due. So you have to teach clients that they should check with you or check on TSDR for the status of a registration and the due dates. And when in doubt, again, they can contact the Trademark Assistance Center. It's Trademark Assistance Center at uspto.gov. By the way, there is also the 800 number on our website. So what about you? What happens if you need to go file a Section 8 or an 8 and 15 or an 8 and 9, and you find out that there's one in the record that you did not expect to be there? Well, this actually does happen. So what we suggest in this situation is, first, review that document and determine who allegedly signed it. Then talk to the client about that to try to determine if the client actually submitted this document or if they know who submitted the document. So if it was not properly signed or not properly authorized, help the client determine if maybe there was a post-registration scam. Very often it'll be a year or 2 years after they received one of those post-registration letters in the mail, and they may have mailed off a check a year or two ago and not realized that they were part of a scam. If they were a victim of a scam, help that client report it to the appropriate law enforcement agencies and their financial institutions. Most banks are required to help with fraud reimbursement. Then file a superseding maintenance submission if there is time left to do so. Report the issue to the USPTO using a petition to the director explaining the circumstances, and then you can go ahead and email tmscams@uspto.gov. Now, that's a lot of steps. That superseding submission is necessary to comply with the statutory deadlines for filing these maintenance submissions, and that petition is needed to let the office know that it's the second submission that needs to be reviewed. So that petition is best practice to let us know what's going on. Failure to file anything could become an issue if it's later determined that that original submission was not authorized or wasn't properly signed or otherwise didn't properly show good use in commerce. Renewal submissions made by bad actors could also preclude important counseling with your client, because if the client is no longer using particular goods or services or not using the mark in connection with particular goods and services, you'd want to delete those in connection with filing the maintenance submission. If that mark is then chosen for an audit and they end up having to delete goods and services at that point, it can get very expensive because there are fees associated with that. Now, in this situation where you're reporting a scam, you can go ahead and request a refund of that petition fee, and those are considered on a case-by-case basis. So what happens if it's too late and your client has already been scammed? Well, first thing is review the record carefully and discuss the scam with the client. You can contact tmscams@uspto.gov if you think that there may be a scam going on and want additional information before talking to the client. But go ahead and talk them through it, try to figure out what happened, how they may have been scammed, and try to get that background information. You may want to consider counseling that client to refile that application if it contains false signatures, fictitious specimens, or other potentially fatal defects. Now, false declarations are a particular problem here because that's actually something that could support a non-use claim in an expungement or re-exam proceeding. It's the type of evidence that the PTO considers for non-use. So in this situation, it could be fatal to the application, and that's why we're suggesting that you may want to think about refiling. If it's another type of submission, notify us as soon as practicable, because we may be able to help you figure out if you could file some sort of corrective or superseding submission in certain cases. So here are some overall scam victim reminders, just general information that I think is good for any situation, not just trademark scams. You always want to report scams to the bank, to the financial institution, to your credit card company. Go ahead and submit a complaint to the Federal Trade Commission. Contact the FBI especially if this is a scam that was facilitated over the internet. The FBI collects information through the IC3, the Internet Crime Complaint Center, and they use that data about reports to determine how to allocate resources. Consider reporting the matter to a local attorney general. The attorneys general generally have consumer fraud groups within their offices. And for phone scams in particular, go ahead and report them to the Federal Communications Commission. So what is the USPTO doing about scams? Well, we're very interested in using information about current and developing scams because we then in turn use that information to warn stakeholders about them, like what we're doing exactly here today. We use this information to issue sanctions to parties who violate the rules. And in some cases, we do share information with law enforcement agencies. So send information to us about potential scams. You can email tmscams@uspto.gov, and we have staff who review this information to determine if we can take action. So we do have to remind you, of course, though, that the USPTO is not a law enforcement agency, and we're not able to help provide restitution of money paid to a scammer. That's why we do suggest reporting it to banks. We do work with law enforcement when possible, but we're not able to go out and arrest people. So we need help to report these things to law enforcement agencies when they occur. And with that, I'm going to go ahead and pause and turn it back over to our hosts.
Thank you, Attorney Franson Mayer, for sharing best practices, tips, and examples of common trademark scams. At this point, we're going to switch gears just a little bit, and I'd like to go ahead and introduce Gerard Taylor. Now, Gerard is from the Office of Enrollment and Discipline, and he's going to lead our discussion on attorney bad behavior and avoiding trademark attorney pitfalls. Gerard Taylor first joined the U.S. Patent and Trademark Office in 2000 as a trademark examining attorney. And then he left the USPTO in 2002, but came on back to us in 2014 as a senior attorney with the Office of Enrollment and Discipline. In this role, Gerard investigates allegations of attorney misconduct, conducts moral character investigations of applicants requesting registration before the U.S. Patent and Trademark Office, and assists the law school clinic certification program. Now let's hear from the Office of Enrollment and Discipline. Thank you, Gerard.
Thank you so much, Marissa. We're going to get started here, but first I wanted to make clear that the Office of Enrollment and Discipline is completely separate from the trademarks side of the USPTO and the patent side as well. Sarah and David did a wonderful job, a very detailed job explaining to you what is done on the trademark side. And there is going to be some overlap, but the Office of Enrollment and Discipline is completely separate as we are in the Office of the General Counsel. So that's a little bit of an introduction. We're going to talk a little bit about ethics scenarios and a little bit of case law. We're going to concentrate a little bit on the U.S. Counsel rule, and then to wind it up, we're going to talk a little about the decorum, how to practice before the office with a little decorum. So the Office of Enrollment and Discipline, trademark enrollment is not really a thing. It's like basically what you need to do to practice before the office and be a trademark professional is to simply be an active member in good standing of highest court in any U.S. state, including D.C. and Puerto Rico and any other U.S. territory. You don't need to take a bar exam. I mean, you all know this. And there is a moral character component, which means that basically that OED has jurisdiction over you. Activities that constitute practice before the USPTO. This is very important. It's very broad. If you take a look at this, this is what gives us jurisdiction, OED jurisdiction over a practitioner. Communicate with and advising a client concerning matters pending or contemplated to be presented before the USPTO. Contemplated to be presented. I mean, that's very broad. Consulting with or giving advice to a client, contemplation of filing a trademark application or the document with the USPTO. Again, very broad. It's not just hitting send when you're filing an application, hitting send on an amendment. It goes well beyond that. It's literally talking to and counseling clients well before you actually hit send on your computer. Now, there is no prescription against employing or retaining non-practitioner assistants, paralegals, et cetera, to help you. There's no problem with that. So this is very important. So the OED's mission is to simply protect the public and the integrity of the patent and trademark systems. So we say it all the time. We want to protect the public. Why are we doing this? To protect the public. But recently, we've even gotten more into the protecting the integrity of the trademark system, because that's what the U.S. Council is all about. You see the statutory authority that we have here and our disciplinary jurisdiction. I'm not going to read that to you. So to begin a grievance in the Office of Enrollment and Discipline, to begin the process, we need something in writing. It has to be in writing. You can't pick up the telephone and tell us what's going on. You can email us, but you can't just call us. You can't just talk to us at a CLE or something like that. It has to be written and submitted to the OED director. And that begins the statute of limitations and also begins the process for us to begin our investigation. Now, it says here that self-reporting often considered a mitigating factor, of course. If you tell us beforehand or after you commit what you may think is an ethical violation, we'll certainly take that in consideration when we're doing our investigation. The time period for forming a formal complaint, this is really important. At OED, we have basically 1 year from the time we receive that written grievance to file a complaint through the SO's office, the solicitor's office, or we have 10 years from the time the actual malfeasance occurs, whenever the misconduct occurs. So my 10 years here, I haven't seen much with the 10 years from the date of misconduct, but I have seen quite a bit of 1 year from the receipt of grievance. That really drives OED. So that means we have to move very fast in our investigations. At the end of the investigation, the OED director may do one of the following things. He may terminate the investigation with no action, which means the practitioner is off the hook. May issue a warning to the practitioner, which means your conduct was not above reproach, basically. We may institute formal charges with the approval of the Committee on Discipline, which means we're headed to trial, or we may enter into a settlement agreement with the practitioner, and then we have to submit that to the USPTO director for approval. So I mentioned referral to the Committee on Discipline. So at the end of our investigation, and we haven't reached a settlement, we know there's been misconduct, or we feel like there's been misconduct has been implicated. We then send our findings to this Committee on Discipline, and the Committee on Discipline determines if the probable cause of misconduct exists. If probable cause is found, then the solicitor's office begins their job and files a formal complaint with the hearing officer. And then through time, over a number of months, maybe even years, the hearing officer issues an initial decision. And once that decision is reached, either party may appeal the decision. There are other types of discipline that occur at OED. One is reciprocal discipline, which is based on what another jurisdiction may do. Like, if you have a situation where you're an attorney licensed in Iowa and you are found to have, stolen money from your trust account, or you also have filed trademarks before, and Iowa decides you deserve a 6-month suspension. Well, we'll take a look at that and probably give you the same exact suspension that Iowa did. That's why we say here it's done on documentary record only. It's usually not hearing. There's no hearing. We just do straight reciprocal. We just give you whatever Iowa gave you. That's just an example. But there's also interim suspension based on evidence conviction of a serious crime, and this is referred to a hearing officer for determination of the disciplinary action. And there's some other things that happen over at OED. We have we deal with some pro bono programs, law school clinic certification program, which is I'm heavily involved in. We have 65 law schools where we basically allow the students to be practitioners before the office. And that's in patents and trademarks. It's a really wonderful program. With the patent pro bono program, we're all over the country as well, and we just are allowing the people who otherwise wouldn't have any money to maybe prosecute their patent. We give them help through professional, experienced attorneys. We also have outreach with speaking engagements and diversion ideas, pro bono, recent rulemaking. There's a lot of other things going on at OED. So mention the diversion program. So back in 2016, there was a study done on 13,000 practicing attorneys where we found that 21% were heavy drinkers, 28% had a level of depression, 19% had some level of anxiety, higher level of anxiety, and 23% struggled with stress, which I think is probably a little higher than that. But anyway, as a result of the study, the USPTO decided to come up with a diversion pilot program, and we launched it in 2017, and it was formalized as a rule in August 2023. It was simply done to try to help people who found themselves in front of OED, but really not through any fault of their own. To benefit from the diversion program, you have to be willing, first of all, willing to participate in the program. The fact that you've been disciplined before, it doesn't matter. It just doesn't matter. But well, I guess it really does matter to specifically what you did. But it's not a bar. It's not a bar to being part of the diversion program. But it's important to know that the misconduct that's been accused must not involve funds, misappropriation of funds, dishonesty, fraud, deceit, or misrepresentation. We don't want to prejudice the person who filed the grievance. It can't constitute a serious crime. Can't be a major pattern of misconduct. And like I said, it can't be something that the person has been specifically disciplined for in the previous 5 years. It's a wonderful program. If you know of anybody who's struggling with these things and they find themselves before OED, please let us know and take part in the diversion program. We're here to help. We're just here to protect the public. So this is just some data about what we've done over the last few years. Warning letters that we sent out, published formal matters, and then reciprocal discipline. I know we're running a little low on time, so I'm going to try to move forward with some of these slideshows here. So you can see here that historically speaking, patent agents and patent attorneys have been the bulwark of our practice. That's just how it's been, how it's going to be. So here are just some situations you might find yourself in, and you want to definitely, obviously, avoid. This is what OED has spent a lot of time. This is what we spend a lot of time on the ethics side. Now, the neglect, like where a client just simply just says he's going to do something and then doesn't do it. Failure to communicate, doesn't return emails, doesn't return phone calls, flat out lying to client. I don't need to explain that to you. Lack of candor to the USPTO, that can be, with us or more likely with examiners. And then the Trademark U.S. Counsel cases have really grown recently, and the invention promotion cases, that's more on the patent side. Now, this is just, I included a few slides here, even though they're patent cases, because they're so illustrative. And if you want to take a look at the OED FOIA reading room, you can find these cases and really dig into them and see what was going on. But this was interesting because he did receive a 2-year suspension. Kroll did, and he failed to file the client's application, but still posted the invention for sale on his website. I thought that was pretty bold. Henry Campbell is a patent agent. I thought this was an interesting case because this was a gentleman who was a patent agent, not a patent attorney, not an attorney at all. He actually he lived in Colorado, and he was representing a person in a DUI case. Had absolutely nothing to do with patents or trademarks or the USPTO whatsoever, but he thought he was an attorney, I suppose. And he was actually excluded from practice, which is the equivalent of being disbarred. This was an interesting case because this was a case where it was just a discovery case, Emory Hicks, where he knew better. He knew that he should not have relied on a case, and he just didn't inform the judge that the case was non-presidential. And, we gave him a public reprimand for that one. So this is where we get into really what's important today. And hopefully be able to help you with your trademark practice. So right now, a great deal of our practice with OED concerns signatures. And I think trademark attorneys should spend some time knowing the signature rules. In fact, they're fairly simple, but in practice, they're very simple. But we seem to have a lot of problems with practitioners not knowing what they can do and what they can't do. I'm not going to read this to you, but the bottom line is, if you can't sign it a wet signature, don't sign it electronically. That's the most important thing to try to remember. I mean, if it's not your signature, if it's not you, don't sign somebody else's name, and don't have somebody else sign your name. We've had so many cases where this happened. I will read it. I'll read parts of it anyway. Each piece of correspondence that requires a signature must bear a handwritten signature. That's not ever the problem. But the problem is when it's an electronic signature, and they must meet the requirements of paragraph C, which is personally enter a combination of letters, number spaces, and punctuation marks that the signer has adopted as a signature, placed between 2 forward slashes symbols in the signature block or the electronic submission. That's basically what needs to be done. The most important thing is that the person enters the signature is personally enter a combination of letters. Personally enter your own signature, yours. Let's move forward. So now we know about the U.S. Counsel rule. We're going to talk about it a little bit. It changed things a lot on the OED side. I know it had changed things for Sarah and David and other people on the trademark side as well. So it became effective in August 2019, August 3rd, 2019. And we all know what it means that foreign domiciled trademark applicants have to be represented by an American attorney. Now, this is just an example of some solicitation email that we received over in OED. And Sarah showed some, and David showed some examples as well of these kind of things that happen on their side. This one is just like, it just lays it right out. I mean, they're literally telling you, we want to rent your lawyer's license. We just want to rent it, and we pay you one fee for the entire year to have your license. So obviously this was something that was done early on in 2019, 2020. They become much more sophisticated in their language. In fact, the next slide is when they actually have targeted, if I'm not mistaken, because this is in Mandarin, they actually targeted somebody who speaks Mandarin, an American attorney licensed in America who speaks Mandarin. So they've just gotten so much better now about doing these things. But you have to really watch to make sure you're not being solicited for these things. And again, Sarah and David did a great job of going over this and making sure that you don't get suckered into these things. So these are some of the decisions that came through the U.S. The OED's U.S. Council rule decisions, and these we have so many. I mean, now I can't guess how many we actually have, but these are just from 2021. I was involved in a number of these. Tony Hahn was a big case. He received 2 years suspension. Jonathan Morton, I believe he received 2 years as well. These are some big cases. And again, I think you should go back and take a look at the OED FOIA reading room to really dig into these cases. And I do recommend that you, if you're going to take a look at the Tony Hahn case and take a look at the Jonathan Morton case. They're really illustrative. And this is from Bloomberg Law. Now, I'm not really sure if this is accurate, but this is what they're saying. Trademark-related sanctions issued by USPTO orders from 2018 to 2023. We see how much has really grown since the U.S. Council rule. Once we really got going here in 2021 and 2022, we really caught our breath. And again, we're going to have, as I said before, we're going to have a year lag. And now 2023, we just really took off. So again, this is something that Sarah and David mentioned, hijacking U.S. practitioner data. You just got to be really careful. And when we see that happen, what we do is that we send all our information to the state bars and other agencies that address the fraud and consumer protection. So we don't sort of leave it up to the practitioner to do it. We also will help out. And some states, honestly, are very vigilant about these things. Some are less so. They just don't have the infrastructure. I can sort of pat California on the back. They do have a good consumer protection agency out there. And some states, like I said, they're not alone. So again, David and Sarah also spoke about the U.S. Council rule, the sponsorship of the USPTO.gov user agreements. They did a much better job than I did, or I could, about this. So I'm going to skip over this. They did such a wonderful job. Okay, so we're going to talk a little bit about what happens when practitioners are dealing with the office. And this is funny, but it's not funny. I mean, it does actually hurt the feelings and the morale of the examiners. I'm a former examiner myself, and I know I'm just trying to do my job, trying to do the best I can. And if I received some of this harassment, it would really, it would bother me. So we have to kind of keep that in mind. I mean, these are human beings behind the wall. Even though we're government employees, we still have feelings, and it really does matter. And OED does care, so that's also really important. So you have to be careful that you don't submit a document that contains rude and discourteous remarks, because it can go to the Deputy Commissioner for Trademark Examination Policy for review, and it can be removed from the file, and it may end up still before the OED, that your conduct. So this is one of the cases that it's kind of famous for us, and that was Henry Schroeder. Again, his remarks were strictly from an application file, and he received a 6-month suspension. This was Tassin. This is a really famous case as well. He left profane voicemails with the TTAB judges. That's not the way to appeal your judgment. And he apologized and said he had the flu and was taking strong medicine, and that's why he said what he said. But he ended up with just a reprimand. So let's move on here. So we're going to wrap this up now. I did want to say 2 things to leave you with, because again, Sarah and David did a wonderful job, but I did want to leave you with just 2 things to think about. As far as practice before the office, being an effective trademark attorney and not ending up before OED. I think the number one thing is that you have to be really vigilant with OPM, other people's money. Make sure you do what you say you're going to do. And, make sure you have an engagement agreement. It's a really good, it's not by law, by rule, but you should have an engagement agreement and correspond as much as you can with email to show, to be able to show OED what happened, but more importantly, so you won't have any misunderstanding with you and your client, especially when there's money involved. Okay, so be vigilant with other people's money. That's number one. And number two, I would say really concentrate on your signatures. Don't sign anything that you wouldn't, don't electronically sign anything you wouldn't wet sign. Do not, and don't have anybody else e-sign something you wouldn't wet sign for you. That's going to wrap it up for me.
Fantastic. Thank you so much, Attorney Taylor, and for Attorney France and Mayor for your informative presentations. We've got some more time, and so let's shift our discussion to our Q&A portion of today's program. This is one for you, David. This is from Jessica. So she's saying that she received an email from someone at USA IP Filers claiming that the law firm was actually affiliated with the U.S. Patent and Trademark Office. I mean, is this a scam? This sounds like a
one.
scam. What do you think?
Yeah, it certainly sounds like one. It would be uncommon for any law firm or any filing entity or claimed filing entity to claim some sort of affiliation with the USPTO. The USPTO does not endorse any particular attorneys or doesn't endorse any particular filers. So yeah, that does sound very odd. When attorneys are contacted by these sorts of entities, the relationship that they may be asking for should be a red flag, because they're probably going to say, we're just going to send you applications and we're going to send you names and we're going to send you what to file. But the attorney doesn't get a chance to communicate it all with their actual client, who is the applicant is their client. And these relationships just would be fraught with problems. So yeah, I'd be cautious about anybody claiming that they're affiliated, and I'd be cautious about anybody trying to get you to file things for them without having any ability to counsel the client.
Okay, thank you for that. Sarah, did you want to add anything to what David said?
I would just advise that, if in doubt, don't provide information to the scammer. Please don't give them your credit card number, and reach out to us, tmscams@uspto.gov, and we can let you know whether we think it's a scam.
Okay, fantastic. I'm going to switch on over to the Office of Enrollment and Discipline with you, Gerard. So you talked a bit about these suspensions that we're all shaking in our boots as attorneys. We don't want that to happen at all. But what is like the longest suspension that your office has had to deal with?
Oh, we do exclusions, and those are, you're excluded. Technically, it's for 5 years, but that's what the rule is. It's for 5 years is our actual maximum, but like I said, it's an exclusion. After 5 years, you can apply to come back in.
Oh, I see. Okay. Great. So it's not a death knell. Okay, fantastic. All right.
Okay.
Let's go. We can only hope. All right.
Right.
So we're going to switch. Oh, Sarah, this is for you. This is from Bruce. Now he's got a question. He wants to know what is being done to protect against paralegals who will assist an applicant with trademark documents, but then the client signs those documents and submits them. Is anything being done about that?
Okay, well, just a couple reminders. First of all, paralegals should only be, working under the supervision of an attorney. Our account agreement says that. I think everyone on this panel can agree that that's very important. Second of all, if a person's name is applied to a document, they need to be the one signing it. Very, very big deal here at the USPTO. They can be submitted and then signed using the e-sign method, but it's very important that a person's name is signed only by that person. As far as situations where a paralegal may be helping an applicant, if you become aware of a situation that they are not working under the supervision of an attorney, that would probably constitute unauthorized practice of law, and you'd want to report that to us and our colleagues over at OED.
Okay. David, anything you want to add to what Sarah just mentioned?
Nope, I think she got it exactly.
She nailed it? Okay. All right, great. Going back to you, Gerard, can you tell us? I know you gave us some great examples of that unethical conduct that the OED investigates. Can you tell us what are some of the most common ones that you're investigating?
Well, right now is the signature issues are huge. That would be the most important, the most common thing we're seeing right now is just paralegals signing attorneys' names, or just people hijacking other people's addresses, and is the scam basically that Sarah and David were talking about. There's a lot of that going on, where people are renting out their licenses, those kind of things. I think that's the number one. That would be the number one thing, and these are all U.S. Council rule issues. Right now, those are the number one things we're dealing with.
Okay. Thank you
And
so much. Yeah.
the thing about the thing about those issues is that I don't think good attorneys are really, especially experienced attorneys, are having those kind of issues. It's mainly newer attorneys, and like David and Sarah both said, these sometimes are attorneys who don't even practice trademark law. They've just been solicited, and because they have a license. They may be somebody who just graduated and passed the bar a week ago, well, literally. So they don't really know any better. And I feel really bad for when they get sucked in, and then they end up in front of us. They get solicited by an unscrupulous foreign actor, and then they end up in front of us when we have to do something. And we end up having to give them some type of sanction. So.
Right. It can be tempting, but
Yes.
as
Easy money.
always, yes, right. It appears to be, but too easy. Watch out. Okay. This is a question for you, David. This is from Jeffrey, and he's like all of us. Once is letting us know that yes, the number of these scams has totally gotten to be absurd, and it's obviously very taxing on our resources. Yes, we're speaking to the choir. We understand that. Yes, we agree. His question, though, is can you advise what is being done to take action against these bad actors? We've talked a lot about that today, but is there some things that you like to raise up and amplify for us?
Well, number one is that we are trying to make changes to IT systems we're between ID verification and the U.S. Council rule, and now ID verification for sponsored accounts. We're trying to make it a little bit more obvious who is filing with us, who are we doing business with, and that's part of the equation. Bad actors will find ways to continue to scam. It's going to keep happening. So beyond the IT changes, we're trying to develop our sanctions program. I mean, we've established the Register Protection Office now, and we're taking action against bad actors by shedding light on the situation. We're trying to draw attention. We're running these types of programs too. And then we are working in certain cases with law enforcement. If it's a true scam that has financial impact on people and there are actual crimes being committed, we do work with law enforcement. Generally, those types of prompts, though, come from law enforcement. It comes from people reporting to the FBI, and it comes from reporting to the attorneys general, the FTC, the FCC. Those agencies have law enforcement powers that we don't. So when they come to us and say, we have this matter that people are telling us about, can you help us through it and provide data and show us how it works? We're very happy to do that. So there's a lot we're doing. It's slow going, but yeah, we are doing it.
Yes, we are actively working. We've got a whole office dedicated to working these issues, so it's very important to us. Okay, let's go back to you, Gerard. So, do you investigate attorneys who act unethically while not practicing before the U.S. Patent and Trademark Office, or do you just focus on our agency?
No, that's actually a good point, a good question. If you're an attorney and certainly if you are a patent attorney, you've taken the patent bar, we have jurisdiction over you, no matter what you do, no matter where you go. The same is actually true if you're a trademark attorney and you file before the office. We have jurisdiction over you. There's been a recent case, and I can't mention too much about it, but the gentleman is a patent attorney, and he's filed plenty of trademark applications, but he's also done immigration work. and he has been sued for basically negligence and neglect. And another jurisdiction has found him, that they sued him for like $150,000 for committing fraud on clients. And once we found out about that, we had to do something, even though it was immigration. It's in a completely separate state across the nation. We can't have, a person like that practicing patents and trademarks when we know that he's stealing money from clients. So yes, we absolutely have jurisdiction, and we actually absolutely do act on those instances. One of my examples was also pointing to that, where the gentleman was a patent agent and he decided to practice before the Colorado states with DUI cases, and we disbarred him. So we didn't disbar him, we excluded him, to be exact. So yeah, we do have jurisdiction, and we do act on practitioners who aren't just bad actors before us, but anywhere they go.
Okay. Thank you. Thank you. I'm looking at the clock. I want to be sure we get a few more questions in before we end our wonderful session today. I'm going to go back over to David, and I'm hoping that Sarah, if you have a comment that you can add also. This is a question from Musi. I hope I'm pronouncing your name right. This is regarding the applicant's email address. We know that email address right now is masked for protection in our trademark status and document retrieval system, our TSDR. Is it possible to also mask the firm and attorney address? Can we mask the applicant's address? What do you think, David?
So there are ways to mask. So to explain the current status of things, the owner email address for an applicant who is represented that is masked. That does not show up in the filing receipt. It does not show up in TSDR. There is a method to mask a party's domicile address. The filer needs to designate a separate address for mailing, and then there could be provided, there is a field for domicile address, and that is masked. It is not provided on the public forms, but it is provided to the examining attorney and to the PTO so that we have that on record. As far as masking other information, one, I would say that phone numbers of any party are actually not required on the form. You'll notice that they don't have a little asterisk. They are not required to be provided. So you can provide phone number information, but even on the signatory field, you can skip that if you'd like. As far as providing attorney contact information, well, we need that information. We need that information to be able to communicate with the party that we're required to communicate with in these situations. And it's also just generally from general practice, we want other attorneys to be able to contact you as the attorney of record regarding that application or later registration. If they, talking about licensing, talking about a potential infringement problem, that contact information is sort of helpful. So unfortunately, that means that the attorneys might have some tolerable amount, hopefully, of bad activity coming at them, but we hope that attorneys are a little bit more sophisticated and will be able to handle that.
Okay, we seem like we got a number of questions for you, David, specifically, and for yeah.
I don't mind being in the hot seat. That's okay.
That's right. You're the expert. But Sarah, do you want to add anything else to what David just said before I bring up another question?
No, I think he covered it pretty well.
Okay, this is from Michelle. Okay, Dave, we're going to keep you right here. This is about the mailings. What about these mailings that are going out to clients? These are, so despite the fact that the client is represented by an attorney, there will be these third parties that contact them, providing misinformation, typically about maintenance fees and when things are due, sometimes sending them way in advance of when that window of filing those Section 8s and 9s are due. Is there anything that the office is doing to handle that? Is that considered fraud due to misinformation?
It is definitely misleading, and we actually have examples of these mailers on a page that we call Scam Alert. So I think we would call it a scam. The question of whether it's fraud is maybe a legal determination that we don't have to get to. Most of these notices have misinformation on them, though. They'll indicate that your trademark is about to expire, and it'll have some renewal date on it that is not accurate. Now, the Department of Justice did secure a conviction against one of the parties that was connected to this type of scam just a few years ago. It's, like most activity, you get one and the next one pops up. So it's continuing to happen. But yeah, the best thing that we can advise on this is that advise clients to one, that they're going to get these notices and they should contact you, their attorney, if they have questions about a renewal. We don't say at this point, we don't say if they get this. They are almost guaranteed to get one of these post-registration mailers at some point. Beyond that, they could check our website on that scam alert page or misleading solicitation page. You can get to it a couple different ways, but it's one of the main scam awareness web pages that we have up on our website. And we actually have examples. So if you scroll down and you see Patent and Trademark Bureau or Patent and Trademark Office, it'll usually also indicate where the mailer came from. And if they click on that, they can see an actual example. And if it matches the notice they got, it's a really good confirmation that this is not a good thing. As far as what we're doing for this, well, when we actually get submissions, we're more aware of who's filing these things. So we are continuing to look into that. We're trying to figure out who is it that's actually filing these things and where are the signatures coming from, and what's the whole situation. Yeah, I'll pause there. If anybody else wants to add anything.
Yeah, just a couple of USPTO resources that you can use, if you're a pro se party or even if you're an attorney. If you have a question about deadlines, please check TSDR. You can also reach out to the Trademark Assistance Center. And finally, if you have questions about a particular organization, look at our webpage, like David mentioned, and there's also our Trademark Decisions and Proceedings tool. So there's a lot of places on our website that you can do some research for yourself if you receive something. And again, always reach out if in doubt.
Great. That's a good point to make. Thank you. Please contact us. Sarah, we're going to end with you. Okay, one question for you, and we're going to wrap it up. Here's a question. I'm going to use the attendee's voice. Can I sponsor an account used by an outside or a contract paralegal who does not work for my firm? Can I sponsor that type of account? Maybe you talk a little bit about sponsoring an account, sure. And then if this is something you can do.
So under our account agreement, the important thing is that the paralegal is under your supervision and control. There are different arrangements by which that works. If you have questions about a specific arrangement, you can always reach out to us. But in general, supervision and control, those are the main issues. And so just remember that anything that paralegal files, you are potentially responsible for. And I think, Gerard, did you have anything to add from the ethics perspective on that one?
No, the two words you use are what should be on everybody's mind, supervision and control.
Yeah, and if you have specific questions about what the account agreement allows you to do, please read it. Supervision, control, and the other issue is, we describe very clearly in there, what the rules are and who you're not allowed to sponsor. So please take a look.
Okay, and with that, I would like to extend a special thanks to Attorney Sarah France, Attorney David Mayer, and Attorney Gerard Taylor for leading our discussion today. I also want to take a moment to thank our experts who've been responding to your queries. We have the Director for Trademark Register Protection, that office, Mantia Pressy, is here. We have Amer Raha is here, who's a staff attorney in the Trademark Legal Policy Office, and also Dustin Bednars, who's a staff attorney in the Trademark Legal Policy Office. And of course, we have my manager, Jason Lott, who's a managing attorney for Trademark's Customer Outreach. I want to draw your attention to a few reminders before we close out. As I mentioned earlier, around 3:30 p.m. Eastern Time today, you're going to receive an email that contains the following: a link to a survey. I'm telling you, it's only going to be 3 to 4 minutes to fill this out. We always want to hear your feedback of what's working and what's not. You're also going to receive a link to these great presentation slides. We worked really hard on these, and I hope that you are able to take a look and get some of those great hyperlinks. We're going to post a recording of the webinar on uspto.gov and on YouTube in about 3 weeks or so. And finally, as I mentioned, we applied for CLE credit in Virginia. Once we receive confirmation, we're going to email that documentation to our attendee list. And that documentation is going to include instructions on how you can apply for CLE credit outside of Virginia. My name is Marisa Terrell. Thank you for joining us today. Please visit our webpage for more information on our next webinar, www.uspto.gov. Type in events in that search bar and you will find us. Thank you so much and have a great day.